And
We're on.
and you know, so you know, if you want to stop, if you make a mistake, just pause for a
Sure.
second and then go over it. So if you could incorporate the question I asked
Right.
in your answer. So first of all, could you just say your name and identify yourself?
My name is Michael Perlin. I am an allegedly retired law professor. I practiced law for 13 years. I was the chief public defender in Trenton, New Jersey for 3. I spent 8 years as director of the New Jersey Division of Mental Health Advocacy. I taught at New York Law School for 30 years, where I created a 13-course program in mental disability law studies, many of which, probably more than half, dealt with the overlap between mental disability law and criminal law and procedure. In my retirement, besides having some fun, I am teaching online. I taught last semester at Emory Law School, and I'm teaching now at Loyola University in New Orleans in their master's program in criminology and justice of a course in criminal law and mental disability. And 1/4 of that course, we're about halfway through, will involve questions involving the death penalty and people with mental disabilities.
Wonderful. So since we can't put all that on the screen,
Yeah.
how would you like to be identified?
Professor Emeritus, New York Law School. And actually, I would like you to do something I didn't say. I am a co-founder of Mental Disability Law and Policy Associates. I
great.
skipped that.
What was your earliest involvement with people with intellectual disabilities?
When I was a public defender, it was very clear to me that some of my clients, of course, it was called mental retardation then, that some of my clients were, quote, retarded. And some of them were in the jail, and they were not treated well in the jail, as you can imagine. Some of them were in the Vroom building, which was named after some, I don't know, governor, attorney general, but it was the maximum security hospital for the, quote, criminally insane. And they were kept there because they were incompetent to stand trial. And for all sorts of reasons, I wound up doing all of the litigation for people who were in that facility. And when I went back to my office to be a, quote, regular public defender, I also did all of the questions involving persons' competency to stand trial. Some of those people were mentally ill, but some of them were intellectually disabled. So I first came across that intersection representing those people. I mean, a couple of the cases stick out in my mind. These were not serious charges, but what they showed me was how people with intellectual disabilities can get totally lost in the legal system. First of all, anybody with any kind of a mental disability gets lost, but people with intellectual disabilities, in some way even more so, because the system doesn't adjust for it. I mean, there's always been an expectation that there will be people who are mentally ill and, you know, need that kind of a hospitalization. But for people who have serious intellectual disabilities, in 1972, and that was a year after I started in the public defender's office, the U.S. Supreme Court decided a case called Jackson versus Indiana, which is the grandfather of all mental disability law litigation. Theon Jackson was a person who was deaf, who was mute, who was profoundly retarded. His IQ was so low as to be almost not measurable. He was charged with taking a couple of purses off the porches in his neighborhood in Indiana. He had never gone to school of any sort, only had the most rudimentary sign language, is put in jail, and then is sent to the state hospital until, quote, he is no longer insane. Kind of like, what's wrong with this picture? Answer everything. The case goes to the U.S. Supreme Court, and the Supreme Court decides in 1972 that both the Due Process and the Equal Protection Clause apply to these kinds of institutionalizations. A fantastically important decision, a 7-0 unanimous decision written by Justice Blackmun, who got these issues more than anybody. And it also said we're not going to create a bright line for how long is too long to regain competency to stand trial, but Jackson was there 3.5 years, and that was too long. So, armed with this, and let me go back, I'm phrase a little bit. When I joined the public defender's office, I was the rookie. Part of the rookie hazing then was to give the youngest or the newest lawyer in the office the Vroom building cases. These were, because they couldn't be won. The Attorney General would ask a doctor 2 questions. Is the defendant mentally ill? Yes. Could he benefit from treatment? Yes, although brackets, if I asked, well, was he getting that treatment, that question was disallowed. So these cases were all loser cases. But I found this really interesting. Some of the people struck me as being profoundly mentally ill, some on the border. I don't mean borderline personality, I mean just on the border. Some were intellectually disabled. But it was very clear to me, I was representing only, every month or so we'd have these hearings. There was a dozen, 15 people, but the only people I represented were the ones who had the wherewithal and the 8 cents for a postcard. This is 1971. A postcard cost 8 cents to send me a postcard saying, "Dear Mr. Perlin, I want you to represent me." The court treated that as a writ of habeas corpus, and I represented these people. It was clear to me there were well over a couple hundred people in this hospital who I had never seen. They were just completely hidden. So the Supreme Court decides Jackson. I am talking to my good friend, may he rest in peace, Dr. Robert Sadoff, the best good friend and the best forensic witness I have ever seen in my life. And I said, Bob, I know our clients fit in, and he testified for me in many cases. I said, I know our clients fit into this category of Jackson. What can we do? And Bob said, look, Michael, you're a lawyer. File a class action on their behalf. There's a Yiddish word, chutzpah, which means nerve. And it took a lot of chutzpah for me at age 27, maybe, 26, to file a class action, which is a very complicated civil writ. And I did. And the case was called Dixon versus Cahill. And Dixon, our named plaintiff, was perfect for us. He was 18 or 19, maybe 20. He had no criminal record. This was in Camden, which is a very high crime area. His crime was joyriding. He was in the back seat of a stolen car. And he had been in the Vroom building for about 4 years awaiting a disposition on his competency to stand trial. So he was perfect. He was my named plaintiff, and the judge then certified it as a class action. So I wound up representing all 225 people in the Vroom building who were awaiting trial. And once the judge had entered the order, it was a lot of hard work on my part, but it was not the kind of lawyering dipsy-doodle you see on TV movies. I just went and represented them. And when the dust cleared, 185 of the 225 were there illegally, which is astonishing. The most astonishing part is that no one ever noticed, and nobody ever cared. One of these cases was a person who was actually neither mentally ill nor intellectually disabled. And I've done a podcast on this, and I would like you to look up, maybe they brought in the wrong priest. And it dealt with a person from one of the stans in the USSR who I was told was a vegetable. And what I'm just cutting to the bottom line, the one priest they brought in did not speak the dialect of Cyrillic that he did. I got the right priest, they communicated. He was there horribly from 1947, when he was living in a displaced persons camp somewhere in the deepest recesses of South Jersey, until I was successful in representing him in 1973. That case made international news before there was an internet, you know? I remember the guy who did PR for the office showed me there was something in Indonesian, you know? It was written about it because it was such a big deal. On one day, I represented 5 people who, in the aggregate, I think, had been locked up over 200 years awaiting trial. I represent one person who was there since 1928. This is 1973 or 74. So, as a result of all of this, New Jersey created a department called the Public Advocate when Brendan Byrne became governor in 1973, and they added a division of mental health advocacy. And I became, at the implausibly young age of 28, I still kind of shudder when I think about it, I became director of that division. And then I did that work for 8 years. That was much too long, I know, but.
That was fabulous.
Thank you.
We've got 22 more questions, and I want you to get to where
I'll talk
you're
faster.
going later.
Yeah.
But I could listen to you all day. You're fascinating. Could you describe the Atkins case and the decision that came out of that, the Supreme Court?
Sure.
Decision.
In 2002,
Can I ask you to start again?
I apologize, I know. I'll give some background. In 1989, there was a case called Penry versus Lineau. And in that case, the Supreme Court refused to say that mental retardation was an exclusionary characteristic for the death penalty. The Supreme Court reversed itself. It overruled that part of Penry in 2002 in the Atkins case from Virginia, the Supreme Court ruled that one could not be executed if, in fact, one was mentally retarded. We have spent the last 17 years tinkering with that as to what does mental retardation or intellectual disability mean, how do we test, how do we assess it. The Supreme Court returned to it in the case of Hall versus Florida, twice now in the case of Moore versus Texas, but we're not done. And we know that people who are, in fact, intellectually disabled are still given the death penalty, and I believe some have since been executed since the Atkins case was decided. But the Atkins case was important for several reasons. First of all, it was a very important decision in the process of narrowing the death penalty. And two, the majority opinion kind of got the fact that a person with then mental retardation might not qualify for the insanity defense. They might be responsible, but they're going to have a limited capacity. And there is, in addition to that, we know that people with this condition don't make very good witnesses. We know they often confess falsely, and we know that the state knows that. And that's actually one of the issues that has troubled me so much, how in so many parts of the country, prosecutors, in spite of the unanimity of the valid and reliable evidence, continue to pursue this.
Could you say just a bit more about why do we not want to execute people with intellectual disabilities?
The idea is we only are supposed to execute, quote, the worst of the worst. That's kind of the Supreme Court sept on that. And people with intellectual disabilities generally cannot have the kind of thoughtful planning that goes into the decision to commit a first-degree murder. That there are certain limitations in their powers of thinking, in their reasoning powers. They are also much more susceptible to other people getting over on them, and that's always an issue in these kinds of cases. Cases not even involving the death penalty. I mean, if you want a little bit off topic, as you know, I'm a big music fan. I found this whole boomlet of cases involving people busted at Grateful Dead concerts. And it seemed that almost always the person who was given the drugs to cart from one venue to the other was somebody with a disability. And I footnote this in an article. No one's ever picked up on it, but I think that was so interesting. Who has nothing to do with the Grateful Dead as a group, but whoever was running the major drug enterprise there sort of got that they would be more likely to kind of go along. They want to be liked. They don't want to say no. They're much more willing to say yes, to agree. And of course, you say people with intellectual disabilities, there is such a range from people who are just at that. And I think the idea of using the IQ test is meretricious, and it's silly. But who, if we're talking about IQs, are somewhere in that 68 to 72 range, or people whose IQs are profoundly low. I mean, those people are in entirely different situations.
And could you talk about the problem of participating in their own defense and understanding the death penalty and so on?
Well, those are separate issues. I think, number one, I always knew as a lawyer, it was always very important to me the extent to which my client was really part of the team. There are some lawyers who say, no, I'm making all the decisions. I think that's dead wrong. I think it frankly violates the canons of ethics. I always wanted to consult with my client. I wanted ideas from my client, whether my client said, yes, I did it, whether he said, no, I didn't, or didn't say anything. It really didn't matter. I wanted to get from him the best I could get to make his case the best. If, in fact, he pled guilty, to be able to make the most persuasive argument I could make at sentencing. A person with an intellectual disability is not generally going to be able to do that, as well as somebody of normal or above average intelligence. And that puts him in the hole. That means his lawyer or her lawyer is not going to have the data, is not going to have the base of information. Even a question like bringing in coworkers. I mean, if someone doesn't have a job, there's no coworkers. If somebody's family has abandoned them, right? There's no family members. Trying to find other people to speak up for this person, it's a challenge. It's especially a challenge with a client with a disability.
Great. And
stop for a second. Am I doing this okay?
This is fabulous.
Oh, good.
Yes,
Okay.
yes.
I'm taking some more water.
So yeah, could you? I know that a lot of people say, well, our justice system is not about vengeance. So could you address the question
Yeah, I
of-
think that's dead wrong. I think our system, in a lot of ways, is about vengeance, and I think it's vengeance on multiple levels. You know, it's very funny. I don't watch TV local news at home. We just don't do that. I go to a gym now that if I'm there at 4 o'clock or 5 o'clock, the local news is on. And this is I live in Trenton, so this is either New York City or Philadelphia, so these are big cities. This is not small town. And I will generally count how many stories in half an hour are not crime stories. And usually there's one, you know, some new climate control initiative or an off-year election or something, but generally 25 of the 30 minutes are going to be devoted to crime. And clearly the vengeance is a motivator of that. The alleged perp's mugshot is shown and it's there for the audience to seize. So that's number one. Number two, I know there's been, in the last couple of years, some very, very interesting elections in which sort of new style prosecutors have been chosen. Krasner in Philadelphia, others in some of the boroughs in New York. But I think if we look around the country, we see that a significant number of DAs, prosecutors, are there for vengeance purposes and as a way of saying to the voter, saying to the electorate, I will put more people in jail for a longer time. This will make you safer. We know that crime rates are down, and when you tell that to people, they say, well, you're wrong. I don't believe you. It's a very interesting heuristic. I've been defriended by people on Facebook, not that it matters much, for saying that, because it flies in the face of their sort of internally held beliefs. And I think jurors reflect this, and of course, in death penalty cases, you have the extra issue of being what's called death qualified, that a person can't sit on a death penalty case unless they say, yes, I believe in the death penalty. And we know from all the valid and reliable research that forensic psychologists and criminologists have done, that this skews the jury in many, many ways in terms of the extent to which police are believed and the extent to which defense witnesses are disbelieved, et cetera.
So could you relate this matter of a justice system that's about vengeance to the fact that we continue to execute people with intellectual disabilities? What does that show?
Some years ago, there was a case in South Carolina, I don't remember the name of the case, in which there was an editorial that was introduced into the record in which the local paper said, these should be the first people we execute, people with intellectual disabilities, because they can't learn. So if they were ever released, they would certainly do it again. And that's not typical, you know, but I thought that just sort of jumped out at me. Of people, you have to be able to empathize with somebody, not sympathize, empathize. And we find that because people with these disabilities in many ways don't present like people without them, we as a society find it harder to empathize. So there's going to be less compassion that's involved in the decision-making process.
So given that we still execute people with intellectual disabilities, what does that say about why we do it and with regard to vengeance?
Well, I mean, one of the issues, and I think it's really important to think about this, and we've learned this in the last few years, these executions, not just of people with intellectual disabilities, but executions in the aggregate, are very, very localized. We execute in certain counties far more than in other counties. And there was a story a couple of years ago when, I've forgotten the name of the county of where Houston is located. It's a famous county. Had sort of one of the highest rates in the country of executions. El Paso, Texas, at the time, same state, had one of the lowest rates. It's so much based on local politics, who the prosecutor is, the extent to which the press in the county may be supportive, or talk radio, you know, more than the newspapers, be supportive of the prosecutor. So we can't talk globally about this. But if you look at the places where this happens, there is no sense, it is a sense that these defendants aren't really people. And I think that's what it comes down to. They are lesser, and I think it's much easier to do that for people who believe in the death penalty.
Great. Okay, so since the Atkins decision, could you address the question of whether procedures and outcomes have changed since the Atkins decision, and if not, why?
Well, the answer is like any good lawyer would say, yes and no, or it depends. In some jurisdictions, certainly, the state has been much more careful about assessing whether or not someone should be death eligible if, in fact, there is some evidence that they have presented in the past as a person with an intellectual disability. In other jurisdictions, no, that in fact has not happened. And if you look at the cases that have been decided since Atkins, Hall, and the two Moore cases, especially in Moore, where the Texas Court of Appeals just simply refused. In fact, in the Moore case, the second time around, the prosecutor said, yes, this was a mistake, and the Texas Court of Criminal Appeals ignored him. The U.S. Supreme Court has vacated that in March of 2019. That's the most recent decision. There, in what were called the Bracino factors, that was the name of the case, the Texas court, in its wisdom, and I'm being very sarcastic here, looked to John Steinbeck's novel of Mice and Men and took the characteristics describing Lenny, a character in that novel, saying, well, if you're like Lenny, you meet the standards. If not, you don't. I mean, no evidence whatsoever. But that was fine. That was fine for the people in Texas. Of course, there is the whole question as to the extent to which IQ is dispositive, to what it counts, to what extent is adaptive functioning being looked at. But if you look at the Hall case decided, I guess, 2.5 years ago now, what you see, and if you look at the footnotes and you look at the history, you see how Hall, this person with intellectual disability, how he was physically tortured as a kid. I find sometimes when I read that, I have to sort of stop halfway through. There's virtually no one ever on death row who was not seriously physically abused as a child. Many were also sexually abused. That's reality. But when you look at Justice Alito's dissent, characterizing the, I guess it was then called AAM or AAMD, as sort of an elite, an elite group of people who obviously, in Alito's view, did not represent the general population. Well, they didn't represent the general population because they've studied this. These are the scholars. These are the people who've made a career out of sort of figuring this out. And I thought Alito's dissent in Hall troubled me as much as any decision I've read from the court in the last 10, 15 years. Because it repudiates the unanimous view of the experts in this area.
So what is it about the Atkins decision itself that has opened the way for it not to be effective?
When Atkins was decided, stop for a second, I wrote an article about Atkins in the year afterwards in the New Mexico Law Review, in which I listed 13 or 15, I don't remember which, pressure points that remained open after Atkins. Go take a look at that. I mean, I certainly don't remember what they are, but that really sort of set it up. Okay.
Okay.
All right.
So,
Ask the question.
well,
I have the question. Okay.
I know that the court, in one of your articles, you said the court said that states must generally conform to definitions of mental retardation. Could you?
Well, the Supreme Court has gone beyond that, and I think in the last two more cases.
Sorry, could you just go back and just say that
Yeah.
that was what it was at first?
I think when Atkins first talked about states generally doing this, I think that in the decisions, as I said, that was 2002. Hall was, I think, in 16, and then Moore was in 18 and 19, or 17 and 19. I think the Supreme Court has now really kind of recognized the fact that the states need more guidance, that the states cannot be trusted. I mean, many can be, but not all of the states, to do this. And I think the court, especially in the most recent Moore case, has made it very, very clear that these kinds of folk psychology definitions of intellectual disability as reflected in Texas in the Bracino factors simply do not pass constitutional muster. What I am very interested in now, and there's no way of knowing, is are there any other cases that the court is going to take up on this in the next year or two to clarify this even further? And of course, we have a new justice, Justice Kavanaugh, and I don't know how he is going to be about this. He's given mixed signals from the bench in some of the criminal cases, which is, to me, a pleasant surprise. I have no idea what's going to happen. But I think we can't tell yet, Paula, as to what the court is going to do in the future. We don't know. The court is, thousands, tens of thousands of cases come up to the court on applications for certiorari. The court picks maybe 90 to 100 a year. Some are criminal, many are about many other things that have nothing at all to do with what we are interested in. But out of those cases, they're always going to take some death penalty cases every single year, and they're going to look to see what issues are that we take seriously, we as a court take seriously. Are the lower courts not taking seriously enough? I mean, it's interesting when you look at issues of mitigation. The Supreme Court in the first couple of decisions said generally mitigation evidence should be allowed, and then subsequently the court said all mitigation evidence should be allowed because they saw that so much mitigation evidence was being excluded. So this is a pattern. The court decides a case, and then it sits back and says, well, to what extent are lower courts actually doing what we told them to do?
So could you address the question of the unequal protection from state to state by how IQ is defined?
You know, when I taught criminal
Wait,
law,
can you put that
I'm
down
so
and then
sorry.
start?
Yeah,
That's
I'm
okay.
so sorry.
That's all right.
I taught criminal law at New York Law School for many, many years. And I would say to the students the second or third day of class, this is going to come up a dozen times during the course of this class, so we're going to talk about it now. We are a federalist system. There are very few nations in the world that are federalist systems, in which New Jersey and New York can have entirely different laws about something, and that's okay. They can't give a person fewer rights than the U.S. Supreme Court has ordained, but they can give a person more rights as a criminal defendant or as a civil plaintiff. And a lot of students don't get that. I've done a lot of international teaching, and of course in most nations it's not like that, and people look at me like I'm from Mars. It makes absolutely no sense to them whatsoever that these systems are in place. So what we have in the U.S., we have states with no death penalty. We have states with death penalties that are never used. We have states with death penalties that are rarely used, and we have states with robust use of death penalties, California, Texas. Mostly the death belt is the southern states. There's no question that if you take a look at the map and then take a look of the Civil War, I mean, most things are going to look pretty close to each other. And in some of these states, and then again, we're also separating out, most cases death penalty cases come from state court. There are also, of course, death penalties in federal court. I'm going to sound like a law professor, you'll excuse me. There's two kinds of cases, death penalty cases in federal court. One, if somebody commits a federal death penalty crime, like a terrorist crime, or kills someone on a Native American reservation or something like that, or in the furtherance of a bank robbery. But those are very, very few cases. Most federal cases involving the death penalty are not federal cases to begin with. They are state cases that get to federal court when the defendant, having exhausted all of his remedies in state court, files a writ of habeas corpus and says the state courts did not provide him with his full measure of constitutional rights. Not all, but a significant number of the cases that the U.S. Supreme Court has taken up over the years in all areas of criminal law and procedure come from these kinds of issues. So to try to answer the question, it's an unanswerable question, of course. Each state does this differently, and within each state, county prosecutors deal with this differently. So you have to be very, very careful about kind of selecting your target. So you can't talk about Texas globally. You can talk about what Houston was like then, what it's like now, which is very, very different, and what, say, El Paso is like. These are just entirely different worlds. Philadelphia, when Lynn Abraham was a DA, sought the death penalty in an astoundingly high number of cases, certainly the highest of any state north of the Mason-Dixon line. Since she's left, it's changed.
Well, and now could you specifically talk about how states or even counties vary in, I guess states vary in how they define intellectual disability?
Some do, some states do define it, some do not. In some cases, the court simply will say, C. Atkins versus Virginia, or more recently, C. Hall versus Florida. Some states define intellectual disability, not in the context of the death penalty, but in the context, say, of special education law, or of benefits law, or of eligibility for services for people with intellectual disabilities. So it's a real polyglot.
So what does it mean about equal protection if one state defines ID differently than another?
That's never been, to the best of my knowledge, that's never been challenged.
Oh.
Equal protection is whether a class of people is being mistreated. If we have one law that says men can work from 9 to 5, but women can only work from 9 to 3, classic equal protection case. But the fact that Oklahoma says this and Ohio says that, if Oklahoma and Ohio are based both nominally following a decision like Atkins, that's not an equal protection challenge.
Okay, so I'm being a non-lawyer, misspoke then. Could you just give an example of a defendant who lives in one state where IQ, the cutoff point is this?
Oh, sure. When you looked at the Hall case, I believe at that time, 4 or 5 states with the death penalty said 70 is the absolute cutoff. 70, you're intellectually disabled, 71, you're not. Other states did not do that. Other states looked more holistically at adaptive functioning and a whole other variety of factors. The Supreme Court, in saying that reliance solely on this kind of a number was wrong, never reached the issue of other states say differently. The question was, they were looking at the case before it. That's something that non-lawyers don't always see. The Supreme Court sees a case before it. It's not interested in what goes on anywhere else. If, of course, the lawyer in the case brings this up, that's an issue that the court may recognize. When a party files for a writ of certiorari, asking the court, the party will, the person saying, we ask the court to hear these 3 issues. Very often the court will say, the writ of certiorari is granted only as to issue 2, or whatever. And sometimes the court will say, but we are all, the writ is granted as to issue 3, and we are also asking counsel to brief this issue, and come up with something that neither side ever thought of. You know, it's the Supreme Court, you know, they can, I'm a baseball fan, they can put the foul lines wherever they want.
Okay, so we're not even at the end of page 1 yet, so this
How many-
is great.
how much do we
I have
have?
to figure out a way to zoom along here. We just finished question 8 out
Oh,
of 25.
Jesus.
All right. Could you talked in one of your articles, no, sorry, it was one of Bloom's articles, about African Americans, defendants, both file and win a disproportionately high number of Atkins claims. Can you just talk about that in the sentence?
I think one of the issues that may be there, I did not write that. One of the issues there might be that African American people, especially from marginalized economic areas, are never really assessed well when they are children. One of the issues in determining intellectual disability is that it appeared before a certain age. And we know that many children, in growing up in very impoverished areas, the testing is not done in schools, or it's not done well. So they really kind of are under the radar completely. Whereas if you had somebody from Bethesda, Maryland, or Montclair, New Jersey, or like that, the school system would be all over it in a matter of days.
Okay. Could you describe the Daubert decision and how it applies to
You don't want to do
Atkins?
Daubert. You don't want to do Daubert, because Daubert is a civil case that deals with the extent to which expert testimony should or should not be considered by the court. Daubert is, it's even though it was a federal case, it's not a constitutional case. It was based on the federal rules of evidence. So Daubert is not controlling in the states. Many states have adopted Daubert. Other states adhere to what's called the Fry case, a 1920s case from the District of Columbia. I think talking about Daubert is going down a bad path, with the exception of this one thing that I will say, and really that's all. I don't want to spend all time on it. One of the interesting issues about Daubert is this, and this has been written about by evidence scholars, and I'm not one of those. Generally, in Daubert cases, the prosecutor wins and the defense counsel loses in criminal cases, and in civil cases, the defense counsel, representing mostly insurance companies, wins, and the plaintiff loses. This is not a matter of chance. There is a huge bias in terms of of this kind of assessment of scientific evidence in favor of the prosecutor's side.
Okay.
There's a great article, by the way, not for this, by a woman named Susan Rosell called Daubert Schmaubert.
I have it right here.
Oh, you
You
have it?
told me to read it.
Did I?
It's
Okay.
hilarious. It's brilliant and hilarious. Okay, so when, in your paper, A World of Steel-Eyed Death, you wrote about the Strickland decision.
Right.
Can you talk about how that applies to Atkins
Sure.
cases?
First, I have to say about Strickland v. Washington. I second sat that case at the U.S. Supreme Court, and I worked. I didn't argue, but I was the other person there. And David Washington is the only person on whose case I ever worked who was executed, and that was 35 years ago, and it is still there. I can't avoid thinking about it like that. My colleague Talia Harmon, who is head of the criminology department at Niagara University, and Sarah Chatt, who is at Spalding University, just did a paper which will be published within the next year in the University of Michigan Journal of Law Reform, in which we looked at every decision by the Fifth Circuit, that's Texas, Louisiana, and Mississippi, that in which a defendant alleged under Strickland v. Washington that he was given, a couple of she's, mostly he's, ineffective, inadequate counsel, and what happened. And the N of cases was about 203, and in only about a dozen of those cases was the defendant preliminarily successful. And then when you kind of go and do the backstories, you see that as of this point, there's a couple that are still pending, but of those cases that have been decided, only one defendant on resentence has the eligibility of parole. The others were all simply sentenced to life without parole. What you see when you look at these, and we have an appendix in this article that lists the cases, is there are at least 25 or 30 cases in which the defendant had some kind of an intellectual disability. And again, when someone with an intellectual disability has a lawyer who is not adequate, that's kind of a perfect storm for bad things happening. And again, as I said, I've represented many people with intellectual disabilities, not in murder cases, but in matters ranging from street crimes to much lower offenses. And the lawyer, there's so much more responsibility on the lawyer, such a heightened burden to be able to kind of get it and to really work your butt off. There's no other way of saying it. And if you have a lawyer who's lackadaisical about it, it's just not going to work.
So in Atkins cases, what are the kinds of problems that having inadequate counsel, if you could just be
Sure.
very specific?
Well, I mean, there's multiple ones. First of all, do you have somebody like Atkins whose intellectual disability wasn't noticed when he was in school? And going back and finding that, going to that person's hometown, contacting their guidance counselor from 8th grade. And I've told this to people, and some people get it. Other people say to me, Michael, are you from Mars? But it's what you need to do. You may find it, you may not find it. Find out, has this person been living at home? Has he or she on the street living with a friend? Are they ever in any kind of meaningful relationship with a love partner of any sort? We know that people with intellectual disabilities marry at a much lower rate than people without intellectual disabilities, and that's one of the things that's very important in sex offender law, which is another one of my interests. But here too, if you don't have a significant partner, a lot of things are much harder in terms of presenting to the court, and you're not going to look as someone who can be identified with by the fact finders. So that's one set of things. Two, has this person been in trouble all the time, and have they been kind of the other guy, or have they been the lead in what they have done? And has this other trouble been very, very minor things, possession of marijuana, speeding, or has there been, escalating serious criminal violence? You need to see this. You need good expert witnesses, and that's one of the issues. Actually, let me go back. Jesus! I just thought of something. I didn't stop it. Low-level crime. Oh, okay. One of the interesting issues is when someone is subject to the death penalty, again, allegedly worst of the worst, what's happened? Are they the trigger person? Are they the other person who was there when a co-defendant went in to rob a bodega and the gun goes off? Are they charged, in that manner? There's a fascinating study just done in Tennessee of juveniles who were to be resentenced after the Miller case, saying a juvenile can't get life without parole. And A, the disproportionate number of those juveniles who are African American, but B, how many of them involved this kind of felony murder where the defendant was actually not the person who was the perpetrator. Let me go back to where I was. What was the last thing I said? I talked about the defendants.
Whether they were the lead.
The lead,
person.
but I interrupted myself. Oh, man.
Well, that's okay.
No, ask the question again.
The question was, what are the problems in Atkins cases when you have inadequate defense counsel?
Okay, got it. Here's another issue. What quality expert witness is available, if any? In Ake versus Oklahoma, and I was amicus curiae in that case before the Supreme Court, on the side of Glenn Barton Ake, the Supreme Court said an indigent person, when insanity is their only defense, has the right to an independent witness. The Supreme Court improved on that a little bit, updated it a little bit 2-3 years ago in a case called McWilliams versus Dunn out of Alabama, in which it sort of gave more of a role for the expert witness. But neither of those cases involved anyone with an intellectual disability. And the Supreme Court has never ruled on what access a person with intellectual disability has to an expert witness. In this case, most likely a psychologist, not a psychiatrist. So that's issue one. Issue two, how many funds are available? Because 90% of all defendants, but certainly 98% plus of people facing the death penalty who are intellectually disabled are indigent. What kind of funds are available? Who is there in the community who can do this kind of testimony? I have a friend who is a forensic psychologist in South Dakota, and she tells me there's 7 forensic psychologists in the state. So what do you do there? Here, we're in Lower Manhattan. You can go to lunch. You'll run into 7 forensic psychologists probably by the time you get back. Seriously, it's not an unimportant issue at all. Who's there? How good are they? And even more important, how bad are they on the other side? In 1 or 2 of my articles, I have written about what Professor Bob Sanger has unearthed about what are called ethnic adjustments, in which several psychologists have arbitrarily raised the IQ scores of African American and Latino defendants, saying, well, they had street smart, so I'm going to give them extra points. And they got away with this for a while. A couple of those psychologists have been excoriated by the Psychological Association, but apparently not all. And if Professor Sanger had not written his article, I have an idea this would be going on just as it was. I've written about that, as I think you know, as well. But I think that raises an issue, is the legitimacy of the witnesses on the other side. There has been so much literature about this in a mental illness case, mostly focusing on Dr. James Grigson, known colloquially as Dr. Death, who even after he was decertified, I like to say de-stethoscoped, by the American Psychiatric Association, he continued to be called as an expert witness. And I write about this a little in the Steele Eye Death article. And jurors loved him. And that's, the prosecutors called him. And as you know, I believe, I've been writing about prosecutorial misconduct in at least 3 articles about the death penalty. I think this is something that we need to take very, very seriously, and we as a society are not.
Great, and I want to come back to the specifics of the prosecutorial problems, but could you just say maybe 1 or 2 sentences about how inadequate counsel on the defense side, what that means in terms of finding expert witnesses, knowing how to interview them, knowing how to critique IQ tests?
There are multiple issues. Number 1, knowing that you need an expert witness, knowing where to go for that expert. And again, we're in New York City. It's pretty easy. But if you're somewhere out of far away in other parts of the country, and when I say red state instead of blue state, that's a decent meme. But think about places where one town may be 50 miles from another town. What do? If you've ever driven through rural Wyoming, you know what I mean. It's got nothing to do with politics. It has to do with geography and topography. How do you find these witnesses? Are they willing to testify for you? Are they scared to testify for you? And that may be because afraid of how the rest of their business may dry up. How much can you afford to pay them? We don't expect expert witnesses to work for free, nor should we. Yet if we are given a minimal amount of money, they're simply not going to be able to do it. We also have to know what questions we want to ask. Most lawyers graduate law school having in criminal law had 1 day on the insanity defense, 1 hour maybe on incompetency, and nothing else. And this is an area most lawyers know nothing about at all. I have done much of my work training forensic psychologists, training forensic psychiatrists. I speak regularly to forensic psychology and psychiatry groups, and I realize how many of them are so starved for this information, lawyers and psychologists and psychiatrists alike.
Great. What is pretextuality, and how does it apply to death penalty cases for people with low?
I think I created the word. I think it's my own neologism. I mean, basically, I did this thinking about when expert witnesses, when courts make it very clear to expert witnesses how they want them to testify. And expert witnesses wanting to keep getting called by the judge will very often modify their testimony to be in the judge's good grace. And I've written about pretextuality in death penalty cases. I've written about it in all aspects of the criminal justice system. I think it has to be seen kind of hand in glove with sanism, which I've written about, this kind of prejudice stereotype that we think about people with mental disabilities. We slot them, we create myths and stereotypes about them. The same ways we had racist myths, gender myths, homophobic myths, xenophobic myths, they're all the same in many, many ways. This is different, the fact that this is, A, parroted by many people who would be shocked if anybody said anything racist or sexist, and 2, it's certainly under the radar. Most people don't notice it. I think you have to look at sanism and pretextuality together, how they infect our death penalty jurisprudence.
Can you just give a very concrete example of like what a psychologist might say that is sanest? And just start by incorporating the question.
Certainly, if an expert says, I am sure, and I'm quoting Grigson directly, on a 10 scale of 10, there is an 11 out of 10 chance that this person is a sociopath and will kill again. That's sanest. First of all, there's no such thing as 11 out of 10. Secondly, one cannot determine sociopathy simply by an eyeball-to-eyeball conversation. Thirdly, the assumption is there that's ingrained in this, that if this person were to be given life in prison and put in a prison, that he would be extraordinarily out of control, dangerous there. We know from the research that Mark Cunningham and others have done that the people in this latter category commit virtually no crimes in prison. This is all wrong. But we believe this because it's kind of what we want to believe because of how we feel. We twin in our minds mental disability and dangerousness. They are seen as part and parcel of the same thing, and no matter how much valid and reliable evidence there is in contrary, we close our eyes to it. Prosecutors will say things to jurors, and I've written about this as well, and the judge might say, well, he went a little bit overboard, but will not reverse the conviction. Prosecutors have a carte blanche, basically, to lie to jurors about many of the aspects of, for instance, if this defendant is found not guilty by reason of insanity, he'll go to a club med facility and be out in a matter of weeks. We know that there's no question, there's been no question for 35 years, that a person who is found not guilty by reason of insanity spends far longer in maximum security than a person convicted of the same crime. And interestingly and bizarrely, the less serious the crime, the more the disparity. In other words, let's say that Joe and I'm naming your cameraman, who is also male, is probably more or less around my age. Our socioeconomic status might be similar. Say we're both charged with robbery. And say I am convicted, Joe is found NGRI. Joe will do 2.5 times as long in a maximum security facility as me. But now let's flip it. Let's say I am found NGRI of kiting a stolen check barely a felony, low-level felony, and he is found guilty. I'm found NGRI. He maybe will get a year. I will be in for 9 years. In other words, the ratio of time to actual time served for an insanity acquittee is 9 times the length of someone who's found guilty of the crime. And prosecutors say he'll be out in a matter of days. That's no more true than saying the earth is flat, and judges allow them to get away with it all the time.
Why do judges allow them to get away with this sort of thing?
In some cases, there's no objection by defense counsel. And there's a legal rule called plain error, in which if there has to be, the error has to be so profound that it's likely to have tainted the decision of the court. Who knows? Who can ever figure that out? That's one. Two, the judge is probably glad. There are many, many more judges who are ex-prosecutors than ex-defense counsel. Judges also are reelected. No judge wants to see his picture on the cover of the local tabloid in any way saying, let somebody out, especially in the, God forbid, worst thing is that someone is let out and commits another crime. So you've got all of these factors pushing in one direction.
Great. Okay, I just want to read something to you that you wrote and ask you to say it on camera. Okay, you were talking about what a good death penalty defense attorney does, and you say they're frequently criminally underfunded, must search for a way to develop, you've talked about some of this, to develop an authentic relationship with and humanize their client, typically one who's the target of public and media animosity, must investigate for mitigating evidence, obtain expert defense witnesses, investigate to rebut aggravating evidence, and attempt to negotiate a plea bargain where appropriate. So could you just...
I mean, it seems to me that a good criminal defense lawyer in a death penalty case has to do many things. He has to be able to, he or she, has to be able to humanize the client. And that, in a lot of ways, is the first thing, that it's a real person there, and that whatever that person has done, it is a real person like we are all real people. If there's an issue of intellectual disability or mental illness, he must be very, very vigorous about finding the right kind of expert witness and talking to the expert witness, not just writing an email and forgetting about it. When I used expert witnesses, I met with them many times before they met with my client. We talked for hours because I thought we had to do that. I had to tell him everything I knew, and I wanted to know from him, what else should I be doing in my role as a lawyer, especially if he, and I was a child when I was doing the public defender work, had much more experience than I had. These are a couple of things. There is much, much more. We have to always thinking about mitigation. Now, of course, you have the case, and here we always assume that defendant is guilty. We may have a defendant who, in fact, was not guilty, and that raises all sorts of other issues. How do you put up mitigation for someone? Mitigation is, well, I did it, but I shouldn't be given this sentence because of X, Y, Z if you didn't do it. And that raises very, very difficult questions. And I worked on one case I did several cases in Oklahoma in which I served as an outside consultant on whether or not trial counsel did or did not meet the Strickland standard at trial. And in one of those cases, I was convinced that the defendant was, in fact, not guilty, that the guilty party was his twin brother. This is a TV movie never made. Now, it turns out of all the cases I worked on, this is the only one that was successful. He got a remand for an Atkins hearing because of his mental retardation, and he was not executed. But, I mean, that raises a whole other panoply of issues. But one of the things, assuming that the person, in fact, is, does have actual and active guilt, how do you mitigate? What do you look for? And I remember so clearly a case, and this is not a death penalty case, but it was an insanity defense case that I did, in which the expert on the other side said, your client is sane. And I said, doctor, did you see his school records? He said, no. And I said, if you saw those records, might that have changed your mind? He said, no. I said to myself, okay, this is good. Because usually the jury, this is the only time, I used to waive juries all the time in insanity cases because I had a wonderful trial judge who took these cases very seriously. I had a jury in this case for reasons I can't remember why. And I said, well, did you see this, my client's Army records? No. Would it have made any difference? No. And now you can see the jury, who is hostile to me as defense counsel, is turning all of its hostility on the arrogance of this expert witness. So when I put like 4 or 5 different things. So when I put my witness on the stand, I said, doctor, did you see all these records? He said, yes, I did. I said, let me ask you a question. Say today I was able to come up with some more records that you hadn't seen, and I showed them to you. What would you do? He said, I'd ask the court for a recess so I could study them to see if that changed my view or not. And I knew at that moment I had won the case. That's the kind of thing an attorney has to be able to figure out how to do.
Great. Okay, now, you have
How
to
much
leave
time
at
do we have?
11:45, is that right?
11:40, 11:45, yeah.
Okay, all right, so we've got.
I'll talk faster.
10,
You'd like that,
15
wouldn't you?
minutes. We're doing well. Okay, so I wanted to ask you, what are some common problems you see in prosecutors in these cases?
I think there are some prosecutors who don't believe in mental illness. They don't believe in mental retardations. That's all crap. They've made it up. It doesn't exist. It's a denial. It's flat earth theory. That's number one. Number two, some of them, and again, these are not all certainly, these are just, some. Some say, who cares? He did it, he has to pay for it. That notion, that very, very, I hesitate to use the word Old Testament notion of vengeance, but I think that's probably where it comes from. Number three, fear that if it appears that the prosecutor is getting kind of too soft, he will be flayed in the press or on talk radio, or 4, it may come up at re-election. Now, re-election, it's interesting, and I'm going to be asking my students this as the last question in the death penalty week, is that after an Oklahoma City district attorney was taken to task by, I think, the Ethics Committee for prosecutorial misconduct in several of these cases, he then won re-election by a bigger margin than he ever had before. And what do you think about that? And I think that's really an important issue.
Could you talk about prosecutors, you say no, or somebody you were quoted said prosecutors knew or should have known that their expert witnesses offered falsified information.
Right.
Could you talk about that?
No, I think one of the issues is the extent to which prosecutors ride herd on their experts. And on one hand, it's meretricious. We can get an expert to say just what the prosecutor wants to hear, put blinders over your eyes, and don't look at anything else. A prosecutor's job is not to convict, it's to seek justice. And a prosecutor who does that is not seeking justice. And in my articles, the Washington and Lee one, the American University one, and the Bulletin of the American Academy of Law one, I talk about all these other professors, Jeff Kirschheimer, Chris Labogan, others, who have come up with all sorts of remedies for dealing with prosecutorial misconduct. And I think there's lots of ways of dealing with it, but we as a society just simply don't seem interested.
So you said that sometimes they even suppress exculpatory evidence.
Yes, I mean, there's all sorts of cases involving, there was a case called Brady many years ago that said the prosecutor has to turn exculpatory evidence over to the defense. There have been many cases when I taught criminal procedure adjudication, we had a whole week on cases following Brady because the Supreme Court kept massaging it in different directions. It's a very, very complicated area of the law. But we know that the state still, there are many instances in which exculpatory evidence is not turned over. Because the prosecutor believes he did it. He did it because of the gut feeling of the police officer, or the fact that simply an eyewitness, the prosecutor's eyewitness, couldn't lie, although we know how, I mean, it's so clear that eyewitness testimony is so terrible in so many ways. The prosecutor simply doesn't want to acknowledge the fact that the case that he has created may be wrong. Another issue here, too, is he needs the police to prepare the cases. And if the police feel he is walking out on them or she, or challenging them, he is afraid they may not go that extra mile in the next case.
So then could you address what happens to prosecutors who do these terrible things?
Very little. There have been
Could you incorporate
yeah,
that?
of course. There have been very few instances in which prosecutors who are, I use the word guilty in quotes, it's not a criminal act, of egregious misconduct are ever sanctioned. There have been one or two cases in which, in the worst of worst, in which they've been arrested, and those always wound up being dropped. Some of them have been sanctioned by bar associations. But again, you can look at my articles. In the vast, vast majority, nothing happens. A slap on the wrist is harder than what happens in most of the cases.
And can you just talk briefly about ethnic adjustments?
Ethnic adjustments, I discussed this before, so it's on, I've already done this.
Okay, oh,
Yeah.
that's right, okay, you did, sorry.
Yeah.
Okay. What are some common problems you see in judges in these cases? You mentioned that a lot of them are former prosecutors. Are there other things?
You know, I think there's a couple of things. I think, number one, I think there's a difference between judges in elected jurisdictions and appointed jurisdictions. Elected jurisdictions are always looking for the next election, and especially if you've got talk radio, local TV news, tabloid-type press, that's always there. They're also, I think, probably more susceptible to what their friends on the golf course say. Hey, Joe, I saw you, blah, blah, blah. If you're appointed, you know, you're going back to the job the next day. It really doesn't matter as much. I also think if you spend every single day sitting on criminal cases, seeing a parade of 20 or 30 defendants before you for arraignments or bails, most of whom are minorities, most of whom are indigent, everything kind of blurs. And that in and of itself dehumanizes the whole process.
How often do judges rubber stamp what the mental health professional says, or in this case, the psychologist, about the IQ?
That's interesting. I'm not sure I would use the word rubber stamp in terms of that. I have seen very few cases that I was never involved in a case in which there was a real disparity between the IQ findings on either side. But what you'll find is in some death penalty cases, when you're at that borderline, that 72, 69, that, you know, it's my experience from cases that I've read, that judges are going to go with the expert who has the higher number, because that means the case can continue, and that means the person will be prosecuted. Because I have found, you know, and again, I started as a public defender 48 years ago. That's a long time. I have found in many jurisdictions that I've been in, that I've consulted in, I've done some legal work outside of New Jersey and New York, a tremendous pro-prosecutor bias in many places. Not all, at all, to be clear, but in many.
Okay. What do you see as solutions for the prosecutorial misconduct?
It's very hard. First of all, it has to be taken seriously, one, by the head, not just the head of the prosecutor's office. It has to be taken seriously by the state officials, by people in the court system. One of the issues, interesting, when you have reformed prosecutors, and we've had, again, there's been this whole spate recently in some of the big cities of reformed prosecutors who say it's not going to be business as usual. The question is, they're saying that, their press release is saying that. To what extent does that trickle down to their investigators on the street? To what extent?
Take your time.
Yeah. To what extent does that trickle down?
Why don't you start again, sitting up.
Okay. To what extent does that trickle down to the prosecutor who's been there for 20, 30 years, who says, yeah, this guy's going to get voted out of office in 4 years and we'll go back to the way it was before? I have no idea, and it's too early to tell, how much control these prosecutors actually have. I think the bar associations have to take it much more seriously. I think there should be, in certain cases, we know that there have been cases around the country in which state attorney generals have appointed task forces when there's been local corruption in prosecutors' offices about different kinds of things, not about, there's been corruption in other areas. These might be an area in which state attorney generals need to step up to the plate and create task forces and investigate and take it very, very seriously.
Okay. And in one of your papers, you talked about there should be mandatory training, certifications, sanctions, and written policies.
I think you need to have mandatory training for prosecutors in all of this. Most prosecutors, again, there's very few courses in law school, very few have taken CLEs or other kinds of courses about it. They don't know what all of this means. They know what they saw on a TV show, and I think they need to have training. I think there needs to be systems of sanctions that are built in. We now finally have systems of sanctions if a lawyer has sex with a client, say, something like that. There are now very, very clear, I would hope in all states, but probably in most states, very, very serious guidelines as to be followed and what is to be done. We need guidelines like that that are taken seriously. I know that in some jurisdictions, and New Jersey is one of them, lay people sit on ethics committees. And I think that's great. And I think this would be something that would be certainly appropriate for that.
Great, okay. We're getting down to the last.
We're almost, I have about
few.
4 minutes.
Okay. Can you talk about a prosecutor review panel you mentioned at some point?
Yeah, I mean, one of the ideas is that there be a panel set up to review prosecutorial actions in cases of this sort. I think it's a great idea. I haven't seen it in real life. You could certainly, it could certainly be massaged over so that it becomes, a useless remedy. But I think if it is taken seriously, and it's taken seriously by the bar, by the governor, by the Chief Justice of the state Supreme Court, by everybody who is kind of up there in the hierarchy, I think it might have some potential value.
Okay. Last couple of questions. One is, you said that prosecutorial misconduct has been dismissed as harmless error?
Right. There are two kinds of errors in, there are two different kinds of descriptions of errors in appeals. One are cases that are called harmless error, and one that are called cases that are called plain error. Plain error is something that is so egregious, and let me back up. Generally, an appellate court will not consider anything from the trial that was not objected to by counsel at the trial. So you see someone stand up and say, Your Honor, I object. What he or she is often doing is simply preserving the record so that if this case goes up on appeal, it's there. We'll say the lawyer is asleep at the switch. Or actually, I should say this, sometimes things happen so quickly in court, a lawyer can't grasp everything. Then the court says, is this plain error? Is this such an atrocious, harmful error that it probably skewed the entire results? Harmless error is basically the court saying, yeah, it should have gone the other way, but we don't think it affected the results. And basically, I believe harmless error is used simply as a palliative. The court wants the conviction to be upheld, so it says it's harmless. You can't tell if it's harmless because no one has any idea how the jurors would have responded to that. I used to tell my students, it's like saying I'm on the bus and someone asks me a certain stop and I say, watch where I get off and get off 3 stops before I do. Obviously it's a null set. And I think analysis of the harmless error doctrine is precisely that, get off 3 stops before I do.
Great, okay. You had told me 11:45, so do we have 5 more minutes?
We do.
Okay, thank you, bless you. All right, last two
I misread
questions.
my watch, I'm sorry.
Thank you. Last 2 questions. You talked about defense counsel being underfunded.
Yes.
So could you talk about what solutions are there to inadequate defense counsel and mention the underfunding?
It seems to me that the issue of underfunding goes in different directions. Number one, generally, globally, public defenders are paid far less than prosecutors. I believe there has to be absolute parity. Game, set, match. That's there. Number two, we know that in jurisdictions in which there are specific death penalty defense offices, these issues that we've been talking about all morning almost never come up because you've got dedicated, when I say dedicated, I mean that in 2 different ways. Dedicated like, I'm dedicated to playing the clarinet, right? But dedicated to it, that's all they do. This is the sole job of those lawyers. And when you have offices like that, these problems don't appear. So I think any state that uses the death penalty more than an occasional amount, I don't know what that is, but you can figure it out, needs to have these kinds of offices. Texas had one for years. It was defunded. I don't know whether it's been refunded or not. I don't know the answer to that. But those are the kinds of things that need to be done. There also needs to be far, 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 far more funds available for expert witnesses. Let me say one more thing about expert witnesses. And you're getting a preview now of a paper I'm going to be giving in July at the International Academy of Law and Mental Health Conference in Rome. I am part of the International Society of Therapeutic Jurisprudence. And I think therapeutic jurisprudence is a huge part of this. I think it's so important, and almost, as you've seen, if you've read my articles, it's always there. We have a conference within a conference as part of the International Academy Conference, and the paper I'm going to be giving, or one of the papers I'm going to be giving is this. I'm going to say in some areas, we don't need one expert, we need two. We need the expert to say, I evaluated John Jones and I found blah, blah, blah. The other expert to say, you, the jurors, may very likely have these views about the insanity defense, that it's a rich man's defense, that the expert witnesses always disagree, that it's overused, that people are, just get a slap on the wrist. And let me explain to you the valid, reliable statistics that show that every one of these folk psychology beliefs of yours is dead wrong. And there's no court that's ever said that. No statute has ever said that. Anytime there's been a case, it's always been you only get one expert witness. But I believe that one of the reasons we have so many miscarriages of justice is that. So I'm going to put this out. No one's ever written about this before. And now, again, this is a sneak preview. I'll be giving this paper in July, and I'm working on it now.
It's a great idea. Could you just talk about training for defense attorneys, about like teaching them about IQ tests and so on?
Sure. Groups like the National Academy of Criminal Association of Criminal Defense Lawyers run terrific seminars. I was down in Austin, Texas, I guess maybe 3 years ago, this spring, 2 or 3 years ago, talking about sanism, talking about therapeutic jurisprudence. My God, I had a room of about 400 people, and it was great. I do a program every couple of years for the Georgia Association of Criminal Defense Lawyers, which is terrific. But most states don't do that. There is very, very little training. Some states require CLE, not all do, but CLE is generally done minimally. And this kind of work is not done. If I go to my cardiologist, I know that he is board certified in cardiology, that he has taken many courses in heart disease, that he continues to take courses in the treatment of heart disease all the time to keep up that certification. I tell my students when they're about to graduate, hey, guess what? A week after you pass the bar, you can put up a shingle and you can represent people on anything except for patent law. And I see some of them gasp. They don't get that. And I think that's a problem with the way the legal system works. We have certified criminal lawyers in some states like New Jersey. That just means you've done X amount of cases. It's an advertising tool. So you can put that next to your ad in the yellow pages and maybe charge a little bit more. It doesn't mean this person has that expertise. I offer training through our group, the Mental Disability Law and Policy Associates, and I'm happy to do this anywhere. But again, I find there's generally more interest on the part of forensic psychologists than there is on the part of lawyers.
Great. It's 11:45. I
Okay.
was going to ask you one last question about that one vignette on which the psychologists split 50-50. It was about competence to stand trial.
Did I write about it?
Morris, yeah. Is it Morris who did that study?
And Grant Morris, yeah. It's interesting in terms of, do experts agree or disagree? And the trope is that on the question of competency to stand trial, there's never any disagreement. Well, that's wrong. And Grant Morris and a colleague, Ansar Haroun, I think, did this study some years ago in which they found, it was a vignette study, that there was a split almost 50-50. And I thought that was just remarkable. They only gave this to people who were board certified. These weren't people who graduated last week. So you see that, you have to say, boy, these are difficult questions. It's not black and white. And I think that is something we need to keep in mind as we proceed in this enterprise.
You're so fabulous, and I'm so glad that
Thank
you
you.
did this.
I hope it was good.
I'm very grateful. You were wonderful.
Joe, was I okay?
You were terrific.
Good.
Okay. Thank you.
Thank you so much. Thanks for schlepping all your stuff down here. Oh, yeah.
Thank you.
Yeah. Do you have a truck outside for this? Minivan, I guess you do. Drop me a note if you want me to follow up on anything.
Thank you.
Okay.
I've got a bunch of things I want to write to you about.
Of course,
so,
yeah. When will this film be done?
I don't know. We've got between